Hello, I'm Phillip Taylor from Richmond Green Chambers. I'm talking about this book, Clinical Negligence. It's a total publication by Michael Powers, Nigel Harris and Anthony Barton. It's in its 4th edition, which is the red sort of pinky type cover, and it's a very important book. It's a heavy book. It comes from that part of the total stable that deals with really concise works. I've written a number of reviews in the journals and on the internet, and I gave it the title, Revisiting the Medico-Legal Landscape. And what I've said is you've given me the solution, not the problem here. Let me explain why I say that. In the 18 years since the first edition, which was then called Medical Negligence, there had been a massive amount of change from the 1980s in the medico-legal landscape. Michael Powers, the late Nigel Harris and Anthony Barton, with their team, which is an impressive one, are responsible here for producing the definitive work, in my view, on clinical negligence in one volume, which has direct relevance to lawyers, to medics and to all other professionals who are involved in the rigorous and lively debate surrounding this specialist area of negligence. And obviously it is a very detailed area. You have to have a lot of in-depth knowledge, and obviously health issues will remain at the top of the political agenda for some time to come, so it's an important area for us to be aware of. The book has everything that the practitioner needs, in my view. It's a compilation of the experiences of about 80 contributors, set out in an authoritative manner, with an index at the beginning of each of the 56 specialist chapters, which I found of great help because of the nature of the subject they're dealing with. It starts with a simple title in chapter 1, the law, and then clinical governance in chapter 2 as an overview, and then it starts developing from there. It goes into every medical department that you can think of, and it explains the law as it affects all involved in the various clinical activities. It's quite unusual to have a politician as the writer of a foreword, but here it's John Barton MP. It becomes apparent quite quickly that his government continues to consider the structure of the NHS and its future role one of its highest priorities. I say that when this book was reviewed in the middle of 2008. Since then we've had an economic downturn, but I suspect this will still be very high on the agenda. Mr. Barton feels, and it comes across in his writing, that there's an opportunity that was missed concerning what he describes as the truly independent nature of dispute investigation, when many may disagree with obviously his position, notwithstanding the patient problem or human rights issues. And Barton goes on to write the following. He says that there are said to be about 1 million adverse clinical events each year, that's what he calls them, but there are only a few thousand clinical negligence claims. And he rightly puts into perspective, therefore, the approach which lawyers must have concerning this area of contentious litigation. Now, I teach conditional fee agreements, they currently stand, as part of the mandatory CPD work that I do. But I always exclude clinical negligence because I think it's too complex, and we have special rules anyway for that. There's a special risk assessment form in each case, obviously by the nature of the work. Barton says that politics, society and natural justice demand that we have a system that is accessible to all, fair and economically viable. Well, I'm sure we'd all agree with that. And then we get the dreaded word finance appearing, and a surprise statement from a Labour politician, that's in my view, that the conditional fee system supported by private insurance could be the answer. Well, when he wrote that, he didn't know that Jack Straw was going to review it, so clearly they weren't really knowing quite which direction CFAs would go in. Now, it may well be that with the CFA review currently under report stage at the Ministry of Justice, we'll see where we go in 2009. Now, let me move on and say there's much in this statement of law which I barely understand in any great depth, because obviously I'm not a medical person, I'm a barrister at law. But some aspects of the terminology actually which I found extremely difficult when I was a student doing the bar course, although I had an idiot's glossary which assisted me immensely. What I can say is that whilst the book itself does look a bit daunting, it's a heavy book as well, don't be put off. The beauty of the book is that clinical negligence here is defined with a useful degree of clarity, which the subject, when it's explained without the overuse of references, then becomes much clearer to the person reading it. Now, Michael Powers and his team identify the biggest challenge in clinical negligence as the development of what we call ATE, or after the event insurance, and the CFAs, while Mr. Barton, of course, who I referred to earlier, says the future for clinical negligence legal practice is bright and prosperous. I'm sure that's going to be the case whatever happens with the economic performance of the country at the moment. The change that we've got should be embraced, he says, as an opportunity, not feared or rejected as a threat. And I do see that, because remember, we do have this balance, certainly which New Labour have tried to strive for since 1997 with the Human Rights Act and everything else. I think it's a good point that he makes, and he ends with something I've heard many times from former female prime ministers, possibly. Lawyers will need to demonstrate their professionalism by representing the solution and not the problem. That's always what Margaret Thatcher was trying to find. Whether it actually eluded her on many occasions, I don't know. I think she found some of the solutions. But I think here the solution has been found. The three authors do just that. And the work provides, in my view, the solution, not the problem, from which we should be very grateful, because obviously it's a difficult area for all. There are obviously distinguished contributors throughout, and they've created the definitive statement, therefore, of clinical negligence in a one-stop volume, and it's made our litigation lives a great deal easier in the process, in my view. So it's well worth having a look at. Thank you very much. Goodbye.